First of all, if counsel and the representative of the parties will please come forward.
My name is John Kay, and I am representing the Hakalau Point Preservation Association today, which is the appellant. Seated next to me is a co-representative, Mr. Scott Wallace, who is also representing the Hakalau Point Preservation Association. We have the president of the Hakalau Point Preservation Association seated in the audience area over here.
On behalf of the landowner, we have a representative.
Yes, good morning, Mr. Chair. My name is Stephen Strauss. I'm an attorney. I represent Shropshire Group, LLC, and with me today is the manager, Steve Shropshire.
And for the director?
My name is Deputy Corporation Counsel Mike Kagami, and with me is Michael Yee, Planning Director.
Okay. Before we open the hearing for evidence, we do have Shropshire Group's objections, which I think I should rule on first, because they may influence what the parties say in their opening remarks. Shropshire Group objected to Hakalau Point Preservation Association Exhibits A through L, and the appellant objected to Landowners Exhibit 1L. Rule 3.1 says the chair is to resolve the issues on questions of evidence. I will point out in my decision that Mr. Strauss, for the landowner, correctly points out that the rules of evidence of courtrooms do not govern our proceedings, but the only authority he cites in his memorandum were to the rules of evidence. I would point out for the board the distinction between admissibility and weight to be given to evidence. That is, just because something may be presented to us does not mean we have to accept it 100% or as weighty or convincing. That's up for us to decide with each individual piece of evidence. But following the general principle that we should favor the admissibility of things that are presented to us and then give them the weight that we feel should be given to them, I'm going to overrule the general objection to the bulk objection to the exhibits. They can each individually be raised as each exhibit may be offered by a witness if they actually are offered as evidence, and then we can rule upon them one by one. As to appellant landowner's objection to a letter dated April 26, I'm sorry, that's the exhibit proposed by the landowner, 1L. It's a letter dated April 26, 2018, and the association has objected to the admission of that letter. That objection seems to be well taken. It is a statement of intentions regarding planning department requirements which would accompany the future issuance of permits which have not yet been issued, and is more a matter of opinion and intention. It may or may not be relevant to us, and it'll depend on what the testimony shows. The exhibit itself does not seem to go directly to any question that the board will be answering today. The objection to Exhibit 1L is sustained. Mr. Kay, I'll call upon you first on behalf of the appellant. General remarks, if you wish.
Can't hold the microphone. Mr. Chairman and the other members of the Board of Appeals, my name is John Kay, and I do represent the appellant in this case, the Hakalau Point Preservation Association, which is a Hawaii nonprofit charitable organization organized under Section 501c3 of the Internal Revenue Code. We are here today seeking your review of a decision by the planning director of Hawaii County, Mr. Yee, which allows the developer, the Shropshire Group, to proceed with plans to transform two abandoned warehouses which were built in 1920, located next to a cliff overlooking the Pacific Ocean, into several commercial industrial ventures, including the operations of a brewery, a distillery, a restaurant, a tasting room, a food manufacturing / processing facility, and living quarters for a watchman, and to allow the developer to proceed with this ambitious project without requiring a special area management use permit which is also called a major permit. That photo, if you look at it, is what we believe is an accurate photo depicting the two warehouses and their location at Hakalau Point. As part of the applicant's SMA assessment application, the planning director also approved the developer's request to change the boundary lines. Yes?
Mr. K, sorry to interrupt. So that photo that you're pointing to, the record needs to be clear as to what, is that going to be, is that marked as an exhibit in your exhibit?
It is not marked as an exhibit. I have small ones, which we will be later on offering as an exhibit through a witness.
Okay, so it'll be subsequently identified,
Yes.
so the record's clear.
So, as part of the application process, the planning director also approved the developer's request to change the boundary lines of his current two parcels at Hakalau Point, reducing the size of the parcel where these warehouse operations will take place from its current 5+ acres down to 3 acres, and then to expand the remaining parcel at Hakalau Point from the 3 acres to now more than 5 acres. This was also, we believe, inappropriate in this case. We contend that the decision to issue the minor permit was clearly erroneous in this case and inconsistent with the Hawaii State Coastal Management Act, the public trust doctrine as set forth by the Hawaii Constitution and the courts of this state, as well as the rules and regulations which have been promulgated by Hawaii County with regard to special management areas. The state law requiring special management areas is found in Part 2 of the Coastal Zone Management Act. In that act, the state legislature made it very clear that a primary reason for enacting this law was to protect Hawaii's valuable and precious shorelines and related resources. And I'm quoting from the act. The legislature finds and declares that it is the policy to preserve, protect, and where possible, to restore the natural resources of the coastal zone of Hawaii. That's the end of the quote. This is a serious mission, and the law requires county planners to carefully scrutinize proposed developments along the shoreline to ensure that the proposed development activities will not result in harm to the special management areas, which includes coastline communities. When development activity is proposed in a special management area, the law requires the developer to obtain a major permit, unless the planning director is convinced that the proposed project will not have a, quote, substantial adverse environmental or ecological effect taking into account any cumulative effects. And I'm going to repeat that. He must issue a major permit. He must have them pursue a major permit unless he convincingly has concluded that there will be no substantial adverse environmental or ecological effect taking into account any cumulative effects. And the major permit, unlike the minor permit, requires a lot more analysis and evaluation of the project, including, and this is important, including the obligation of the developer to submit environmental reports regarding the impact that his project may have on the special management area, which includes the impact that it might have on nearby residents living in that special management area. Equally important is the fact that when the developer is required to pursue a major permit, the public is invited to participate. They're told to share their concerns. They're invited to provide input as part of the development process. In this case, the decision by the director to issue a minor permit has resulted in approval of a large-scale project that will impact the surrounding single-family residential neighborhood, which is a large single-family residential neighborhood by Hawaii standards, with increased traffic, noise, alcohol use, safety risks, noxious smells, and increased strain on limited infrastructure, and other adverse impacts, as some of the members of the Hakalau community will, I think, express to you later on today. Moreover, by issuing the minor permit, the director has allowed the proposed development to proceed in the absence of that public input regarding the community's concerns and possible mitigation measures that could have been implemented through this process. It is also very, very important to keep in mind that one of the primary missions of the Coastal Zone Management Act is, and I'm quoting again, to promote public involvement in coastal zone management processes. End of quote. And in this case, the planning director's decision was to exclude the public from the decision-making process for what we believe is an extensive project. By issuing the minor permit, the planning director apparently concluded there would be no substantial adverse ecological or environmental effect, and he made this decision with full knowledge that this project consisted of completely transforming 2 empty and abandoned warehouses and constructing inside of them 6 new facilities, and then operating within these 2 buildings all of the industrial and commercial ventures that I described to you before: distilleries, breweries, restaurants, tasting rooms, watchmen's quarters. Now, and again, all of this commercial activity would be occurring just a few feet from the Pacific Ocean cliffs on one side, as you can see in that photo, and a residential neighborhood consisting of some 22 existing homes on the other side of that. This decision by the planning director to excuse the developer's obligation to secure a major permit was harmful to the community, and we will show that the approval was based in part on misleading, vague, and incomplete information and representations provided by the applicant in his special management area assessment application. There is little question that this wide-ranging project will impact the surrounding single-family residential neighborhood with increased traffic, noise, smell, safety problems, pollution, and other distressing consequences in contravention of the desires of the Hakalau community, as evidenced, as we will point out later on in this case, by almost 600 residents having signed a petition in opposition to commercial development and industrial development as described. When projects are to be performed, I should say, in a special management area, county planners must first see if the work constitutes development. This is the first step. Is it development, as defined in the law? In this case, the planning director did rightfully conclude that the project did constitute development under the law, and also expressly determined, and I'm quoting, that the proposed improvements and as-built structures as presented are not exempt from the definition of development. So in other words, Mr. Yee rightfully said this project is development, this proposed project. However, when it came time to evaluating the potential environmental and ecological impacts of the proposed development, the planning director was completely silent about possible adverse environmental effects that might occur from operating a brewery, a distillery, a tasting room, a restaurant, a food processing plant, and watchmen's quarters as proposed in the applicant's project plans. Instead, the director's written determination was limited to only mentioning, I should say, a few of the construction activities intended to occur outside the warehouses. I quote, this is from the determination by Mr. Yee. Quote, although most of the proposed actions are primarily interior improvements to buildings A and B, the fencing of the arsenic contamination area, landscaping, and the as-built water tank and carport are not expected to affect the project area involved and the surrounding areas, nor, quote, I want to highlight, have a cumulative impact or substantial adverse environmental or ecological effect on the SMA. Nowhere in the entire decision by the planning director is there any discussion, there's not even a mention of possible adverse environmental effects resulting from the construction activities which are going to be taking place inside the warehouses. And even more importantly, there's no mention of possible environmental effects that might result from operating all of these ventures, the brewery, distillery, and so on, from inside the warehouses just a few feet from the Pacific Ocean. We believe that the planning director's failure to assess these aspects of the project was clearly erroneous. In allowing the developer to proceed with a minor permit, the planning director erred on 2 counts. Number 1, first, the law expressly states that a major permit is required where the development, quote, may have a cumulative impact or a substantial adverse environmental or ecological effect on the special management area, end of quote. We contend there is no reasonable way that the planning director could determine from the vague and incomplete information submitted by this applicant that the proposed operations would not have a cumulative impact or a substantial adverse or ecological effect on the special management area. We will also show that the information provided by the applicant was so non-specific that without obtaining more information from the applicant, no planning director would have been able to conclude that this proposed project will not result in a cumulative adverse impact or a substantial adverse environmental or ecological effect on the special management area. It was clearly erroneous to issue Mr. Shropshire a minor permit based on the scant information contained in Mr. Shropshire's submission. Second, there is one more prong that must be satisfied before a developer can avoid the requirements of the major permit, even if the applicant had submitted sufficiently detailed information regarding his proposed project, and even if the director had provided some rational basis to conclude that the development, after looking at all this information, would not have an adverse environmental impact, the law makes it clear that the developer will still be required to satisfy the requirements of a major permit when the proposed project or the development has a valuation of more than $500,000. Let's be clear about this. If the development has a valuation of more than $500,000, then case closed. The developer must obtain a major permit and satisfy all the procedural and substantive requirements for obtaining a major permit, which includes, again, public hearings and submission of environmental reports. In this case, we believe that the planning director erred by simply accepting without further investigation or scrutiny the bald representations made by the developer concerning the cost of the developer, which the developer stated would be $434,860, some $60,000 shy of that $500,000 limit. We believe that the evidence will show that the amount stated by the developer is patently low and should not have been so quickly embraced by the planning director. In fact, we believe that the documents which comprise the planning department's official record in this case, which is more than 1,000 pages long, I believe, was already established that the developer's valuation of $434,860 was transparently low, and that the actual cost to set up the proposed development would far exceed $500,000. And finally, and I am wrapping up now, another reason for rejecting approval of the planning director's decision to issue the developer a minor permit in this case stems from the failure of the planning director to comply with the legal obligations set forth in the state of Hawaii's public trust doctrine, as described in the Hawaii Constitution and amplified by the courts of this state. The evidence in this case will reveal that the planning director did not analyze, did not scrutinize the proposed project as required by the public trust doctrine in accordance with the courts of this state. There will be much more on this later. And the last point is changing the boundary lines. We believe that the planning director did clearly err when he approved the developer's request to change the boundary lines of the two parcels that Mr. Shropshire currently owns. The parcel which houses the two warehouses currently comprises 5.1 acres. The remaining parcel at Hakalau Point currently makes up 3.6 acres. The developer requested a change to now have the parcel comprising the two warehouses be shrunk from 5.1 acres to 3.6 acres, and to then have the remaining parcel increased from its 3.6 acres to 5.1 acres. We believe that the planning director erred because there was no justification for this change. Even Mr. Shropshire's own justification was inaccurate and wrong, and because the granting of the developer's request now will result in a zoning violation at Hakalau Point. On behalf of the Hakalau Point Preservation Association, I'm sorry it took me so long, and the community we represent, I thank you for your time and serious consideration of this matter. Thank you.
Members of the board, I submitted a pre-hearing brief that identifies the law that needs to be applied and also includes as an appendix parts of the Coastal Zone Management Act, the Planning Department rules, the appropriate Planning Commission excerpts from Rule 9. And so I did that to guide the parties because that's what we're really talking about here, is whether this permit complies with the law, whether the planning director complied with the law, or whether, as the appellant contends, there was clear error there. Clear error must be based on evidence, not argument, not wishes, not preferences, but on evidence. And let's start with the appellant's appeal that sets forth its case. There's no evidence there. There's no studies that there's any potential substantial adverse impact from this project. There's no expert reports. There's just value preferences. We don't want it, and we think that it shouldn't have been granted, and we don't believe the numbers that are associated with it. Mr. K made what I consider to be a serious misstatement, essentially saying that the planning director simply accepted the numbers that were offered by the applicant, by Shropshire Group LLC. Well, you're going to hear from the planner who was responsible primarily for processing this application, Esther Imamura, whose job it was to review the application, to communicate with the applicant, to apply the law and the appropriate rules. And she'll talk about the additional information that was required from the applicant. And this is not a rubber stamping process. She takes her job very seriously, and she'll be here to testify about that. One of the things that you will likely be concerned about is the arsenic that was briefly touched on by Mr. K. And we have from the Department of Health, John Peard from the HERE office, the Hazard Evaluation Office, to testify about what the plan is going forward for cleaning up and for remediating the arsenic contamination that involves other parts of the property, and how the department views that and his requirements that are adopted by the permit as a permit condition. It's clear that the appellants wish that this was a major permit. It's not. It's a minor permit. And that's what you have to decide upon, whether a minor permit was properly granted in light of the appellant's burden to show evidence that there was clear error. So that's what you have to be keeping in your mind. What evidence will be presented by the appellant to support their arguments? Not their arguments, but the evidence. The evidence that there is substantial ecological and environmental impact, the evidence that these are abandoned warehouses, which they are not abandoned warehouses, the evidence that it's consistent with the community that existed long before these folks ever bought their property, including a hospital and other commercial uses on these and adjoining properties. And then with respect to the arguments concerning zoning and non-conforming lot and, consolidation re-subdivision, the evidence will show that the planning director properly dealt with a non-conforming lot and a conforming lot, and that the consolidation result in subdivision will result in a non-conforming lot and a conforming lot, consistent with the practice. Shropshire Group LLC doesn't want anything different than every other applicant that comes in before the planning department, produces their application and be treated like everybody else. But the appellants want something different. They want you to treat it as if it's something that it isn't, an SMA major. It's not. It's an SMA minor, and that's what you have to base your decision on, whether they clearly erred in granting an SMA minor for this proposed development. Thank you.
Yes, real brief. It is the planning director's position that he correctly assessed Mr. Shropshire's application using the processes and the criteria contained in the rule governing this type of application.